All right, so that was more of the prosecution's closing arguments. I want to bring on our very own Bob Bianchi to the set. Bobby B, how are you, sir?
I'm doing good. Vincent, how are you, my friend?
Man, I'm well. Hey, I just want to bring something up here in about a minute that we have. The prosecution said something that stood out to me, that Van Dyke knew nothing about Laquan or his life, right? Now, I will say in an officer's defense, having done that job, when you're receiving a call for service to deal with an individual, you're not going to know anything about them. You don't have time to go and talk to their family. You don't have time to look them up on social media. You don't have time to do any of that. So why is she driving that point home to the jury?
You know, I don't know, Vincent. That's a good question because we've actually heard this a couple of times coming out from the prosecutor. Apparently, the prosecutor believes that this is something that's relevant, but I don't think the jury, it's going to have any big significance. I guess she's just saying, essentially, he didn't know what was in the mind of Laquan at the time. But as you've noted, police officers rarely have that opportunity, and you've got an armed suspect. It's not really a lot of time to be able to do some biographical research.
Right, absolutely. Bob, stick with us. We want to now switch over and hear some of the defense closing arguments. All right, so that was some of the defense's closing arguments. You just heard his closing statement. This was a tragedy, but not a murder. Still with me, our very own Bob Bianchi. Bob, I want to talk about some of the things the defense said here during his closing arguments. He talked about the use of force policies. He talked about when an officer can use deadly force if it's believed to be reasonable. But I want to go back to yesterday when Van Dyke took the stand, right? He said that Laquan was advancing towards him. He said he was advancing on me. He was between 10 and 15 feet. But as I go back and watch that dash cam footage, and again, I've done this job, you can clearly see Van Dyke actually taking a fairly large step towards Laquan, which would suggest quite the opposite, that Van Dyke was indeed advancing towards Laquan and not the other way around. And I hope we can play it here. There you can see that step from the officer, Van Dyke, before shooting Laquan. So to me, his statement doesn't match up with what the dash cam footage says there. He was advancing on me. I could see his eyes. They were bugged out. What say you, Bob?
Are crystal clear, which makes the defendant's testimony a killer against him. One, Laquan is moving on an angle a little off center. You got a line right down that road that you can see him moving away. Secondly, as you've indicated, the officer is moving towards him, not the other way around. And thirdly, which I thought was brutal when he testified, was that he indicated he thought that he was backpedaling, i.e. the police officer said he thought he was going backwards, when clearly the video shows that that did not occur. Vincent, it's startling to me that a defense attorney would know this would be the testimony of the officer so easily contradicted by the video and put him on the stand.
Yeah, you know, as I watched yesterday, I said, man, if I was that defense attorney, I don't know if I would have put Van Dyke on the stand. You know, he came across, you know, fairly decent when he was being questioned by the defense. But, of course, when the prosecution got on there, it was, oh, I can't remember. It was stressful. And listen, I get it. I've been in those high-stress situations. You don't understand it, but it moves in slow motion as you're doing it, but it's actually going pretty fast. You're making split-second decisions, so you don't remember everything as you live that. But when you look at footage like this dash cam footage, it's so compelling to say that what Van Dyke said yesterday just does not match the evidence. And I don't see how, personally myself, I don't see how the defense can actually overcome this, Bob.
Yeah, well, it's a tough case to overcome. It probably was more likable that they could justify the first round of shots, Vincent, but they're going to have, obviously, a very difficult time trying to justify the latter part of his testimony, which is even more absurd, that when he's down on the ground, he continued to shoot because he thought he was still a threat. It's going to be really hard to get past that. Now, the defense lawyer may be trying to play a middle game here. Look, I don't want him to be convicted of murder, which is obviously a very serious sentence, but something less than murder.
Right, and to your point, I think maybe the first couple of shots, maybe you could justify that, but these other shots, really, Bob, it's really hard to articulate or justify that. We're going to take a quick break here on the Law&Crime Network. We'll be right back. We have more in Chicago. We got a lot to cover. We actually have top crimes coming up on the other side. Stay tuned. All right, thank you for that, Anthony. Still with me, our very own Bob Bianchi. Bob, listen, man, I wore a uniform for many, many years, and to to hear this story. This guy's going out. He's a sworn police officer. He's picking up a prostitute, and he does the biggest mistake ever. You leave a prostitute in your car while you're running to the ATM. You can see him there on your screen there, and she steals his car. I mean, I've heard of a lot of dumb stuff, Bob, but I think this takes the cake.
I mean, come on, Vincent. We all know. We all tell our friends, don't take your prostitute with you to the ATM. It's not a good idea. I never did it. I'm sure you never did it. But this guy decided to do it. What arrogance.
You know, Bob, I don't know if it's arrogance or just plain stupidity. Like, first of all, you're a sworn police officer. You're going around picking up prostitutes. And listen, the city of New York's pretty big, so you don't know if the person you're picking up is actually a fellow New York City police officer doing an undercover prostitution sting. I mean, this whole thing, Bob, is just, oh, God, ridiculous to me, man.
You know what, Vincent, when you see guys like this, and, you know, I've actually represented some cops in scenarios where they've done kooky stuff like this, lawyers, you got to go right, send them right to the psychologist. And I'm not saying that kiddingly. I did say the ATM thing kiddingly, but not this. There is something that is obviously psychiatrically wrong to put everything on the line, drug, alcohol, you know, there's something there.
Yeah, absolutely. I couldn't agree more. And I understand what cops go through. I've done that job. I think to do something that outlandish, there's something wrong. You know, again, whether it's drugs, alcohol, mental illness, we don't know. We want to switch gears. We want to talk about Michelle Carter. You may remember she actually was texting her boyfriend, who was claiming he was suicidal, to just kill himself. Well, he did. And now Michelle Carter is asking for an appeal. Let's take a listen. All right. So, again, Michelle Carter is appealing her conviction. She was texting back and forth with her boyfriend, who was suicidal. You heard this mention of a truck. He actually put himself in the truck and killed himself via carbon monoxide poisoning, which is not a very quick way to die, I got to tell you. I've worked one of those cases. Still with me, our very own Bob Bianchi. Bob, with this case, right, I mean, we have these text messages, and listen, I've been in a few relationships here and there. I get some strange text, but I don't act on them. So how do you actually convict someone by saying, well, you text him to do it, so therefore you're guilty of what he did. You aided in that. How do you get there?
Well, first, let me be my blessings and thanks that I got married prior to the advent of text messaging and social media. That said, it's an interesting case. It's an interesting theory. But let's remember here, if I got the facts accurately, because I commented a lot about this at the time, he was actually in the process of doing that and was saying he wanted to get out of the car, or I don't know if it was a text or they were on the phone.
Right.
And she was insisting, no, get back into the car. So I think that was the relevant conduct at that point of time. I agree that if you were going to hold people accountable for bad things that they say and unfair things that they say and all those previous text messages prior to the day of the death, that is a standard I don't think they're going to go to. I think they're adding it to what was done literally while the act was occurring, and that kind of put a different spin on this particular case, Vincent.
Yeah, I mean, I understand that, but to your point, I mean, if that's what the standard is now, I think a lot of us will be in trouble. I mean, I've sent some text messages that probably weren't too favorable, you know, to that person, but, you know, that's what the court decided.
She was also explaining to him how to do it. She was showing him how to do it. She was encouraging him how to do it. So, you know, you don't need to literally be in the car to aid and abet. And I think I think that's why it's going to survive Supreme Court scrutiny here. But anything less than this, I think, goes to your point and would not be prosecutable.
Absolutely. Bob, stay with us. We got to take a quick break. We'll be right back here on the Law and Crime Network. All right, so there was more testimony from Jason Van Dyke in the cross-examination by the prosecution. Bob, there was a few things I pointed out there. He was a little combative with the prosecutor. I mean, I don't know how I'd act on the stand, especially when I'm fighting for my life, you know, life in prison on this murder charge. But the prosecution said something here I want to point out. She said, why did you shoot him center mass? But the fact of the matter is that's how police are trained to shoot, right? So as a prosecutor, is that a question you would have asked that defendant on the stand?
No, I wouldn't, because, it was just a knee-jerk reaction. The prosecutor knows the law and the training, and that is the weird part of this case. They kind of switched roles, and he had a perfect opportunity to give the knock-it-out-of-the-park answer,
right.
Is that you're right, ma'am. I shoot to neutralize the threat center mass, and I may have fired too many rounds, but at the time I was scared, I was frightened. He had a knife in his hand. He had assaulted the police car or cut the tire or whatever, and so I kept shooting in order to neutralize that threat. But he doesn't pick up on that. He goes into this whole thing about how I thought I was backpedaling,
right,
and how I thought he was getting closer to me. So while she made a mistake in asking the question, he made a mistake in how he answered it. And, you notice him using the words. I think he's trying to think too much here.
Yep.
I didn't mean to do it intentionally. Look, the lawyers had to have known this guy was going to make a horrible witness. It's ultimately his call, but he really sealed his fate, in my opinion, with his testimony, even though the prosecutor made that little, little hiccup there about that question.
Yeah, absolutely. I think, to your point, he was a little too surgical in his answers. You could tell he was giving it way too much thought, right? So that doesn't really come across as natural here in this case. We're going to go to a quick break. We have so much more to come here on the Law and Crime Network. You don't want to miss it. That jury is on verdict watch right now. Jason Van Dyke on trial for murder. Stay tuned to the Law and Crime Network. Hey, welcome back to the Law and Crime Network. We have a lot going on. Of course, the jury in the Jason Van Dyke case is on verdict watch, but they came back in the courtroom during the break to ask for more instructions in those charges there. So that's very interesting. Also, of course, Daniel Villegas in the state of Texas, he was convicted for a murder when he was 16 years old. This is his third trial. Of course, he says his confession was coerced by police, so he's being tried right now. They will have closing arguments at 5 p.m. Eastern time. Of course, go to the Law and Crime Network, lawandcrime.com, to follow that there. Michelle Carter, again, she's appealing her conviction there with her boyfriend, who committed suicide by carbon monoxide poisoning. So a lot going on here at the Law and Crime Network. Right now, let's switch gears and look at the top crime stories of the day.
Here are today's top crime stories trending on lawandcrime.com and across the country. A teen in Florida is under arrest for allegedly luring men she met on a dating app to meet up so she could rob them, and then warned the men they would get in trouble if they went to authorities since she was underage. 17-year-old Ednita Leon Alamo reportedly posed as a 21-year-old woman named Emily Perez on the dating app Meet Me and set up dates with unsuspecting men to rob them. When dates arrived for a meetup, they were greeted by 3 armed men wearing ski masks instead of Perez. Leon Alamo and the 3 suspects were eventually arrested and now face 2 counts of armed robbery. The Dallas Police Department has refused to release the audio recording of the 911 call from Amber Geiger, the former officer accused of entering her neighbor's apartment thinking it was her own and fatally shooting a man. Geiger reportedly returned home to her Southside Flats apartment after a shift, but entered the wrong apartment. That's when Geiger shot and killed her 26-year-old neighbor, Botham Jean. Geiger was terminated after an internal affairs probe found she engaged in adverse conduct. Geiger now faces a manslaughter charge and was released after posting $300,000 bail. One of New York City's finest was reportedly caught with his pants down when he hired a veteran streetwalker who stole his personal car and service weapon while he stopped at an ATM to pay her. 38-year-old NYPD officer Ali Shepard allegedly picked up prostitute Taquanda Lawton in the Brownsville section of Brooklyn, but before their rendezvous could begin, Lawton stole Shepard's Jeep as he withdrew cash from an ATM. Lawton was arrested several hours later and now faces criminal charges. Shepard was suspended and could face disciplinary charges pending an internal review. Those were today's top crime stories. I'm Anthony Velez.
Hey, Anthony, thanks so much for that. Hey, Bob, I just got to say 2 things. Plenty of fish, Match.com, prostitute.
Actually, I was going to say something a little bit different. I mean, we already said you don't take your prostitute to the ATM. Some of the people that are chatters had some good things. Or if you do, make sure you take your keys with you.
Take your keys.
Yeah, that was a really good one. I think Addie sent that one out from the chat room. But maybe even another one. Like, can't you go to Yelp or something and get the rating? I mean, for honesty, integrity. I mean, there's honor among thieves.
Right.
It's just, you can make a lot of jokes about it. But yikes, man. I mean, You're right. There's plenty. I think that these guys that do this, Vincent, in my experience, it's almost a thrill. It's not like the fish and you can go and you could go. They like to be on the edge doing something that's crazy like this. They're almost begging to get caught.
Yeah, absolutely. I mean, I don't even know if I would have reported this, especially as a police officer. I picked up a prostitute. She stole my car. I don't know if I would have reported it. I probably would have just tried my OnStar or something like that. I don't know.
I didn't know that he reported it. And if that, in fact, is correct, that he reported that while taking my prostitute to the ATM, my car got stolen, then we know for a fact he needs to go see a psychiatrist.
He needs to see something. I mean, this gives all new meaning to serving the community. Godly. All right, on a more serious note, of course, Jason Van Dyke is on trial right now for the murder of Laquan McDonald there in the city of Chicago. He shot him 16 times back in October of 2014. We want to switch gears while that jury is on verdict watch and listen to some testimony from a use of force expert in this case. Take a look. All right, you just saw some very interesting stuff there in that courtroom. The prosecution holding a knife in his hand, talking to this use of force expert for the defense. Still with me, our very own Bob Bianchi. Bob, you and I were talking during this about closing the distance between someone armed with a knife, right? I've been through that training. Listen, in the police academy, I got stabbed 3 times. Luckily, it was a fake knife. But a lot of times, it's just a 1 or 2 step maneuver. So you have this prosecutor in the courtroom holding this knife and the use of force expert saying, yes, I would consider you a threat because you were that close to me.
You know, Vincent, there's so much to this testimony that we've just listened to only here at the Law&Crime Network, right? So, yes, it was a bad move for the prosecutor. Usually you pick a weapon up and demonstrate that to show the lethality of the thing. And the prosecutor's used to doing that, but this happens to be a cop case. So he's doing it. He stands there with the knife, and he asks the expert the ultimate conclusion. Would you consider me a threat if I didn't drop it? And the answer is yes. And in front of that jury, that ominous-looking knife, and him standing there holding it down in a suit, in a courtroom, in an antiseptic nature where nobody can get hurt, is not what was going on at the scene. So I think it was a bad move by the prosecution. Now, if we got a minute or so, I'd like to talk to you about a tactical move with the defense expert that I think the defense should have done.
Mm-hmm.
Yeah, so what that is like, remember, our audience should realize the defense expert can testify about all sorts of extraneous data, including the defendant's statements. So in essence, he can get the defendant's testimony out on the record as how he came to the formulation of his conclusion. So you don't have to put the defendant on the stand. And the reason you don't want to put the defendant on the stand in a case like this is the law is favorable to the police because they have an affirmative obligation to protect the community. So that expert should have been the last witness, period. The defense backtracked by putting the defendant on and obliterated the expert's testimony, in my opinion.
No, I couldn't agree more because, again, as I watched Jason Van Dyke yesterday, I was thinking to myself, why did his attorney put him on the stand? And you're right, you have that expert, this use of force expert, albeit he's paid by the defense, but he's sitting here telling you. And to me, in that courtroom, holding that knife, although some people will argue, well, the blade wasn't that big, it wasn't that long, it wasn't a machete. I can tell you a cutting instrument will go through a bulletproof vest. So there is that danger there. I think you're spot on, Bob. I would have left that testimony to this use of force expert. I would have left it right there, and that would have been it.
Right, and like you said, I've gone through the Police Training Commission training well with firearms, and they use this actual scenario with a person with a knife, and in one scenario, the person drops the knife, and that's one scenario. In the other scenario, they stab somebody by closing that gap. So this is the training police officers are given to make a split-second decision. Now, when you're on that machine, in the antiseptic nature, again, you're not really in harm's way. You find you're shooting the guy who dropped the knife, and you find that you're not shooting, and he comes and attacks you. So this is where you want to go in terms of the training. And then with respect to the remaining second volley, Vincent, you heard the expert. He was very definitive the first round was justified. I think that was completely believable to a jury if done the correct way. And the second volley had a little bit of difficulty with, but he went and got more data and more information. You leave it there and you let the law drive the not guilty verdict.
Absolutely, Bob. I mean, ultimately it's up to the jury to decide what happens here. I would urge anyone to go out and just YouTube the 21-foot rule as it relates to knife attacks. You'll actually see what Bob and I have been discussing here. He's had the training. I've had the training. I've been stabbed. Luckily, again, a fake knife in police training. But, you can only speculate what was going on in Van Dyke's mind in that split second. That's what officers do. They have split seconds to make decisions. We're going to toss to a quick break. Remember, the jury in the Jason Van Dyke trial is on verdict watch. We're waiting that decision. Stay tuned to the Law and Crime Network. All right, so there's more of the prosecution's closing statements. Still with me, our very own Bob Bianchi. Bob, I want to talk about something. She mentioned premeditation in this, but I go back to something I said earlier at the top of the show. You heard testimony from Van Dyke that he told an officer, we're going to have to shoot this guy. We heard testimony that he said, how come someone hasn't shot this guy? So doesn't that kind of lead to the whole premeditation element of first-degree murder? He had this amount of time where he's riding to the scene, right, in his car. He's making these statements. So wouldn't that in itself lead to premeditation?
It's certainly a relevant fact, and clearly one that the prosecutor wants to and is hammering home. But premeditation can be formed in an instant. But nevertheless, yeah, the issue here, though, is not to be confused by the idea that every officer, you know this, Vincent, who decides to shoot center mass and take somebody out is premeditating, is intentionally committing an act. It really doesn't get to the legal issue of the case as to whether or not it was a justified shooting, because officers have an affirmative obligation to protect the community. So while she's citing the right law that she wants the jury to hold on to, the issue really is whether or not it was justified given the legal permissive use. And, you know, Vincent, I'm thinking as I'm listening to this, look at all these cases where cops have testified or been charged as defendants with unarmed people and have been found not guilty. Some of them have been really, really bad. Here it's a little bit better for the defense because it is an armed person who had a violent encounter prior to the police encounter, then a violent encounter with the police. Now, that's a very relevant fact. He attacked the police car, so there's going to be a heightened suspicion. You would have been heightened as well. Right. Again, all this would have been perfect if it came through the defense expert, without the defendant testifying, because the defendant testifying, he couldn't even articulate what it is we're articulating right now. Yeah, absolutely, and I think that's what it will come down to here in this case. But you saw there was that fence there, so of course to the jury there's that question, was Laquan a threat to the public? Based on what we saw on that dash cam. We're going to take a quick break. Again, the jury for the Jason Van Dyke trial is on verdict watch. We'll have much more to come here on the Law and Crime Network. Stay tuned.
The defendant finished.
So that was more from the prosecution closing arguments. As you could see there were some pretty graphic pictures there of Laquan McDonald. Again, he was shot 16 times. Still with me, our very own Bob Bianchi. Bob, I think showing those pictures there of Laquan, again, a 17-year-old kid shot 16 times by Van Dyke, I think that's going to play on the jury just to see how actually Laquan was shot, the extent of his injuries there. We saw shots to the elbows, shots to the chest. You saw a shot to the mouth there. There's a lot going on. I think that will play heavy to the jury. What say you?
Yeah, you know, usually when these autopsy photos are being shown, they're supposed to be shown for relevance purposes as opposed to inflaming the passions and emotions of the jurors. In fact, the judge will instruct them as to that. These photos, however, are particularly relevant in terms of the charge against the officer as well as the defense. And of course, the number of shots fired is one area of relevance, but also the shots to the back and in the multiple places where it would be clear that he was no longer posing a threat to the officers, as we previously indicated. So they're highly relevant.
Yeah, absolutely. And it goes back to what I believe, what I've said from the start, for Van Dyke to say Laquan was advancing towards me. And you mentioned those shots to the back. And all right, we can argue if you know, one or two of the shots initially were justified. You know, we weren't there. I don't want to Monday morning quarterback, but you know, again, it's up to the jury who's been deliberating for about an hour. We're going to toss to a quick break. We'll have much more to come from Chicago right here on the Law and Crime Network. Stay tuned. Okay, so there's the defense in his closing arguments, the Jason Van Dyke trial, and still with me, our very own Bob Bianchi. Bob, I want to touch on something. One word: compliance. I say that a lot in my law enforcement training. Compliance. You saw the defense attorney say this could have been prevented had Laquan done one thing, and he actually drops the knife in the courthouse. And listen, it was 16 shots. I get that. It was very tragic, but I really can't say I disagree with the defense attorney here that had Laquan dropped that knife, maybe we wouldn't be here. What say you?
I think the defense attorney did a very effective job at playing to at least one juror at this point, Vincent, after the defendant's testimony. I just need one, he's saying in his head, to say not guilty. He's looking for that one that says this guy was a criminal, he's been in jail before, he was up to no good breaking into trucks, he wasn't responding to the cops, he assaulted the car, popped the tire. I'm not putting this cop away based on that with this guy with a knife. He's looking for that one juror or two to hang the case.
Yeah, and really that's all it takes in this case. You know, one juror that can say, yeah, you're right, Laquan was out doing this stuff. He, had this knife with this couple, and then, he slashed these tires. He's not listening to commands. You see several officers there on the scene in that dash cam footage. So there's a lot going on. This is not very easy and black and white as people may assume it is. I don't envy that jury for sure. Bob, I want to thank you for sticking with me this entire time. It's been my pleasure, my friend. As always, I'll be signing you off. Thank you.
Thank you, sir. Okay.
I'll be signing off as well. We still have so much more to come out of Chicago. Again, that jury is deliberating in the Jason Van Dyke murder trial. I will be signing off. Aaron Keller will be joining us, the guy with the pretty hair. I'm trying to get my hair like that, but I can't. So much more to come in the city of Chicago. Again, Jason Van Dyke is on trial for the murder of Laquan McDonald. Stay tuned to the Law and Crime Network. We'll be right back in just a few minutes.